This is advertising material.
Thank you for joining us. I'm Claire Bianovich, and my co-presenter is Cindy Effinger. Over the next couple of weeks, we anticipate that the stay-at-home restrictions across the country will be lifted. We already have a plan here in Kentucky, and organizations will be going back to work little by little. What that looks like will be different for each state and each industry. We're going to focus mainly on Kentucky here because we have a lot to discuss. But if you have questions regarding other states or any questions at all, actually, feel free to type them in. I understand that Brian, my handy dandy assistant, is going to be kind of collecting them, and then Cindy and I will go through them at the end. We do want you to know that we're going to share our recommendations, but you really want to look at your local restrictions, the health department restrictions, and the CDC as things go, because things are changing very, very quickly. So I'm going to advance to the next slide. I'll be discussing preparations to ensure a smooth transition back to the workplace with a focus on Kentucky's Healthy at Work initiative. And Cindy is going to address kind of what goes wrong and how to handle it when things do go wrong. Again, the World Health Organization and the CDC and your local and state health departments are the final word. We all have a responsibility to reduce the spread, and as employers, we are integral to this process. For the time being, for the health and safety of our community, we recommend that you continue to allow those who can telework to telework. And continue that as you're reshaping your plan to reopen, to have a safe phased reopening. Okay. Brian, I'm on relevant law, so let me know if we're in the same place. So there are a couple of laws that we want to discuss briefly before we get started. We have OSHA, and that generally requires an employer to provide a workplace free from any recognized hazards that are causing or likely to cause death or serious physical harm. And violations of OSHA are subject to enforcement actions and civil penalties. Cindy is going to get into that in more detail, but OSHA did just state that they are going to offer compassion and understanding for employers who don't get it right. And so as long as you make a good faith effort to comply with OSHA standards, I think that the civil penalties and actions of enforcement will be limited for a brief period of time. The National Labor Relations Act also protects employees from adverse employment action. Generally, this deals with engaging in protected concerted activity, and that could look like refusing to go to work, petitioning your employer for safer work protections. The employees do not lose protection of the act if their good faith belief is wrong. So you might have a situation where a group of employees refuse to go to work because they believe that there is a hazard, and they are eventually that hazard is disproven. It doesn't matter, they're still protected under most circumstances. In Kentucky, your first stop guidance, by the way, would be the Healthy at Work guidelines. That is at KYCOVID 19.ky.gov. And there are minimum qualifications that we're going to discuss in detail here. They also span businesses, across businesses. Another relevant law is the ADA. Next, I'm on the next slide, Brian. Obligations to make reasonable accommodations for folks who have a disability that put them at a greater risk of contact. We also are going to talk about HIPAA, deals with privacy of patient health information, and Families First Coronavirus Response Act. And then, of course, we have some state and federal wage and hour laws. So that's kind of the world of the laws that we're going to be dealing with. There are also specific rules in addition to the minimum requirements that are listed. There are also specific rules based on industry. see, we have a phased opening May 9th, places of worship were open. May 11th, we had a phased opening of construction, horse racing, manufacturing, distribution, office-based businesses at 50%, pet grooming and boarding, photography, and vehicle and vessel dealerships. Each of those have specific requirements related to their ability to open. May 18th, we have government offices and agencies. May 20th, funeral and memorial services are allowed to reopen, and retail if they qualify. And then May 22nd, I know we're all looking forward to restaurants opening at 33% capacity, and groups of 10 people or more able to congregate. So those are some things to look forward to. All right. So the first thing you want to do is establish a pandemic coordinator or a team if you haven't already done so. In Kentucky, we'll call this a healthy at work officer. It's basically the same person. You want to allocate defined roles related to preparedness and response planning, and you're going to want to kind of discuss all of the things that we're going to touch on today in that team. The team should include at least one individual with knowledge of employment issues. You want to establish an ongoing communication with local and public health departments and develop a communication system to ensure that your information is being transmitted and the government information related to employer responsibility is being transmitted to your employees. One of the primary obstacles that we see in creating this team will be combating employee anxiety. As folks go back to work, as they transition from the quarantine back to work, there's going to be a lot of anxiety. So we want folks who have the dual talents of being able to calm folks down and give employees a place to turn to with their questions. So a communication plan is imperative. So along with somebody who is skilled in employee laws and relations, you might want to have a communications individual or somebody who is skilled in marketing or PR. You want to establish a team who will get folks on board and who will buy into your plan, because compliance for you is required, but you don't want to have the additional stress of employees deciding that they don't want to comply with your rules. Okay, so the next slide deals with sanitizing the facility. This is one of the first things you guys should do when you go back to work. And the first plan you should establish is how to sanitize the facility. If people have been in the facility in the last 14 days, you want to sanitize in advance of reopening. You want to open all windows, all doors, and increase air circulation. The person that you assign to clean this facility really needs to be trained regarding appropriate donning and doffing of PPE. The CDC has a great tutorial on this online that's good for this individual, but it's also good for any training you put together for your employees. You want to ensure that the individual has the appropriate PPE, masks, gloves, eye protection, coveralls if necessary, depending on your business. Now is also a really good time to check your inventory of cleaning supplies. We've all been running low. So we want to make sure that we have enough, not just PPE, but cleaning supplies to last us for at least 2 weeks. And so now is a good time to check on that. Okay. Again, with sanitizing the facility, you want to clean and disinfect all surfaces, paying attention to high touch surfaces. So just like in your home, you want to make sure you clean your tables, your doorknobs, your light switches, your countertops, handles, anything that is touched often. You want to do a real thorough cleaning, and you want to set up a schedule for cleaning those regularly. In terms of the remainder of your facility, you want to launder soft surfaces such as rugs and drapes. You also want to make sure that you have appropriate use of your PPE and avoid contamination after you clean the facility, and wash your hands immediately after removing your gloves. So pretty common sense stuff. The next step for your team would be to establish an infection control protocol specific to your business. So some engineering controls that you might want to think about is, first of all, install or clean air filters. Install physical barriers to separate employees who don't need to be in contact. Kentucky requires 6 feet of distance between folks, if at all possible. You want to reconfigure your workspace so you can accomplish that. That might mean eliminating half the desks if you're in an open environment, or staggering them. It could be utilizing conference areas that can no longer be used for conferences to house desks. You might want to remove non-essential doors that are in high touch risk or are affixed to an open area, so folks don't have to touch doorknobs. You might want to designate signposts for traffic in crowded areas. In terms of administrative controls, essentially what you want to do is minimize contact among workers, clients, customers, and you want to reduce face-to-face meetings with virtual meetings when possible. Again, you might want to alternate days or shifts to reduce the total number of employees in a facility at any given time, if this works with your business model. To reopen in Kentucky, employers are tasked with ensuring that the employees are safe and at a distance. So really look at the way your office operates or the way your business operates and try to accomplish that goal when possible. The next task is to create a safe workspace. You want to make hand sanitizer available at every entrance and exit and at multiple traffic areas throughout the facility. You might want to hang a wall-mounted disinfectant at every entrance and exit. Provide disinfectant for personal work surfaces. If you have an office area, put them at each desk. If you have a retail area, make sure they're by the cash register. Provide extra tissues, trash receptacles to throw away any kind of refuse. If exposure in your industry is high, you need to provide PPE. And actually, since the Healthy at Work restrictions have come out, this has changed. You are required to provide PPE as necessary. So all masks are required for all employees. We're going to get to that in a minute, so I'm not going to dwell on that right now. You also want to designate, in terms of creating a workspace, designate a place for employees to store their personal items. So if you're used to using a coat closet that's shared, you want to separate those items and create another means to store their items, their personal items. Okay, establish routine cleaning schedules for common areas. Again, high touch areas are at particular risk. You want to clean those 2 to 3 to 4 times daily, depending on your operational hours. So, every hour, every 2 hours. And then perform routine cleaning of other surfaces. And again, you want to train your staff to perform these routine cleanings, create a log, and create a record. And by the way, the CDC has another guideline about cleaning that's really helpful, and so I would refer you to that. Again, in terms of cleaning protocols, you want to establish cleaning protocols in advance of folks coming back, in terms of what do you do if someone is sick. And the CDC recommends that you close off the area, that you open all outside doors and windows if that's possible, and that you clean and disinfect all areas possibly used or touched by a sick person. And again, I'll refer you to the CDC for great advice related to cleaning an exposed area. I would also recommend that you post signage alerting your employees that an area has been contaminated. Depending on how big your facility is, this might not be communicated to all employees, so signage is helpful. Okay, so once you have a clean facility, you want to establish a testing protocol. There are a number of protocols that your team is going to have to establish in advance of opening up. You want to establish a pre-return and work testing protocol that deals with who you are bringing back and when. You want to develop a routine staff testing protocol. Kentucky requires a daily temperature check or screening process. So you want to get that in place. You want to develop a routine, for some reason this is routing, but it's routine visitor patient testing protocol. So how are you going to test visitors, or are you going to test or screen visitors? You want to develop a tracking system for employee absences due to COVID-19 qualifying reasons. And all of these things, you should document your protocols and document your logs related to those protocols. So going back to Kentucky requirements, they do require a daily temperature and health check of the employees. We're going to discuss that a little bit later. And so I'm going to jump ahead a bit. But I would like you to think about at this stage, when you're developing these protocols and these logs, I would want you to think about in advance how you're going to handle non-compliance. And Cindy's going to kind of touch on that a little bit more. But this is when you're going to be making those decisions, because you want to have a uniform policy related to that. And not just for employees, but also for visitors and customers. So going back to that idea, you want to establish emergency protocols. You want to establish emergency protocols related to patients and visitors. You also want to determine how your business will operate if your staff gets sick. Identify who performs essential business functions and who can cover those functions if your essential workers are absent. You want to cross-train. Make sure that you have coverage if you need it. And finally, you want to establish a recall plan. This should be done on a case-by-case basis based on non-discriminatory reasons. So if you are put in a position where you have to decide who to bring back in, you can make those decisions based on core business operational need, seniority, or exposure to and recovery from COVID-19. Generally, by the way, going back to the last slide, I'm sorry I skipped. Generally, by the way, employers can ask employees if they believe they've been exposed to COVID-19 because COVID-19 is not necessarily a medical condition. Employers should exercise care in doing so because they want to avoid claims that they discriminated against an employee based on their knowledge of such exposure. But asking an individual if is fine under ADA rules. So the example they gave in a recent FAQ is asking an individual if his immune system is compromised is a disability related question because a weak or compromised immunity could be closely assimilated with conditions or associated rather with a condition such as cancer or HIV or anything like that, where an inquiry as to whether or not you have a cough or you have a sneeze or you have COVID-related symptoms is not requesting information about a disability. Okay. Okay, so going back to your policies that you should implement. You want to implement a couple of policies before you bring people back or in advance. Emergency Paid Sick Leave Act policies and request forms, Emergency Family Medical Leave Expansion Act policies and request forms. If you're a small business, you may be available, you may have an exemption, and I think Cindy's going to get into that, so I won't deal with it at length. You also want telecommuting or work from home policies if you don't already have them, and you want to update discrimination and harassment policies. And just so we have some basis of knowledge about the Emergency Paid Sick Leave Act, that allows paid sick leave for an employee who's unable to work or telework for one of 6 qualifying reasons. They're subject to a quarantine order, advised by a healthcare provider to self-quarantine, experiencing symptoms or of COVID and seeking a medical diagnosis, and you have to be seeking a medical diagnosis to qualify, or the 4th is caring for an individual who is subject to a quarantine or self-quarantining. And then finally, caring for a son or daughter due to a school closure for a COVID-related reason. There is a 6th, but nobody knows what it means because the government hasn't really defined it. And the FMLA Expansion Act extends coverage for employees who have to care for a son or daughter due to a COVID-related school closure. Okay, prior to returning to work, we now have an affirmative, Kentuckians now have an affirmative duty to educate their supervisors and their employees about the healthy at work rules and protocols. So that is an affirmative duty. You want to make sure you provide clear expectations regarding infection control procedures as well. You want to educate supervisors and employees about their requirements to wear masks. Masks are required to be worn by all employees, volunteers, contractors in the workplace, unless there is a medical reason why that's not healthy or it creates a safe hazard, or if the employee is working alone. So walking around your office or your business, you should be wearing a face mask. And the employer is required to provide those masks. Employers also have an affirmative duty to train staff regarding the cleaning requirements, the cleaning protocols, so all of those things. While you're there, I recommend that you train supervisors regarding discriminatory or retaliatory behavior and proper donning and doffing of PPE. So if an employee's business requires the use of gloves, for instance, a cashier would be required to use gloves because they work in a high touch area. You also want to train those employees and supervisors regarding how to safely remove those gloves. Okay, so in Kentucky, we do have a temperature check rule and a healthcare screening. Many experts are petitioning Congress to also incentivize employer testing. So it could be an antibody testing or it could be a COVID screen test. So far, we haven't heard about that, but we're still waiting. Workplace testing would, in fact, accelerate reemployment and maintain a healthy workforce. So we're hoping that that passes. But in the meantime, there are other things that we can do, like temperature checks, like creating a daily screening log. If you are performing temperature checks, and we're going to, again, get to routine testing in a little while, I do want to remind you that these folks, the person who is physically conducting the temperature check, would be at a higher risk. So again, we want to provide those people with the PPE that they need. So maybe it's not just masks, maybe it's gloves, maybe it is glasses. And you want to have a thermometer that doesn't come in contact with any bodily fluids. Let's see. So health screenings. Businesses now must conduct daily screenings to ensure that employees don't have COVID-19. And this is all businesses in Kentucky that are going to reopen. It's in the minimum requirements. So we have a choice. We can either conduct in-person on-site screenings at the beginning of the day, and that's a temperature check and a questionnaire, or we can have that screening, at least the temperature check, occur at home. There's a question as to whether or not you want to have the verbal questionnaire screening done at home, and I think that's, again, your preference. But either way, there are certain questions that you want to ask. If you do put a live person to perform the temperature checks and to perform the healthcare screening, there might be a line. And so employees might have to wait to have those screenings each day. That is compensable time. That waiting time is compensable time. So, for wage and hour periods, I just want you to be aware of that. So screenings are to identify if employees have any CDC recognized symptoms, or if anyone in their home has a diagnosis or a symptom, or has been in close contact. So the questions that you're going to want to ask, and again, you can either have this done by the employee at home and have some kind of recording or some kind of reporting done, or you can do it on site. You want to ask if they have a cough, do they have shortness of breath, do they have a fever, and that's defined by 100.4 or above. Have they been experiencing chills, muscle pain, or sore throat? And again, these are symptoms that cannot be explained by any other reason. So, if somebody comes in and says, I have muscle pain, but he's been working out like a dog, then that's not covered. You don't have to worry about that. And then additional questions, have you been in close contact with anyone exhibiting symptoms? And that could be in your household, or that can be out in the world. So again, here are some of the things that you want to know for daily screenings. Fever over 100.4. Employees with fevers should not report to work. Employees who say yes to any of the screening questions should not report to work. And you want to make sure that they either, before reporting to work, get a COVID-free test. In other words, a negative test for COVID-19, or are cleared for from their physician. And that might be, maybe they're cleared because they actually have the flu. So can employers measure a body temperature to determine that they have fever if they're on site? Yes, recent EEOC guidance has said affirmatively, employees can take temperatures. I would still recommend a no-touch thermometer, by the way. What do you do with these readings? So you have to exercise care when keeping these readings. And this is true however you receive this information, because these are considered medical records and there are legal restrictions that go along with it. You also want to create a process and a policy to log these readings, to collect this information, and to store this information, because you will need it later, or you might need it later. Verbal confirmation is not enough. So it's not enough if your employee calls in every morning and says, I'm good. That's not enough information. Okay, if an employee is diagnosed with COVID-19 after reopening, what do you do? First, you send the employee home, and you don't allow them to return to the office unless they have either a negative test or a physician permission to return. Okay. You ask the COVID positive employee who he or she has come in contact with, and you track where they've been in the facility. You sanitize the area in which the COVID positive employee worked and any area that they encountered. And so the CDC says that contact with a COVID positive person, and contact is defined as anything less than 6 feet for a prolonged time, and that's 10 to 30 minutes, requires that the employee be sent home. So if you have a COVID positive employee who has been around other employees for more than 30 minutes and with, in less than a 6-foot distance, you have to decide whether or not to send those folks home too, and determine whether or not they have been exposed to COVID-19. So if you get into that situation, I would recommend you call counsel, because you might be put in a position where you conceivably have to send home your entire workforce. So you want to kind of figure out where those parameters of safety are. Okay, if you work in a shared office building and someone is diagnosed with COVID-19, I would recommend that you alert the building manager. They might want to take precautions. If there's an elevator, if there's common ingress or egress, they're gonna want to take precautions as well. You want to notify the employees with whom the COVID-19 positive individual had contact with. Do not disclose the identity of the positive employee. Simply say, you could have been exposed to a COVID-19 positive individual, and request that those employees get tested. You want to alert the remaining workforce that an employee has been diagnosed on site. As far as I know, this is not mandatory that you alert the remaining workforce, in other words, non-contaminated or potentially contaminated employees, but it is a very good practice because, again, you have anxiety in your workforce and you don't want them to hear from anyone else. So when you alert the remaining workforce, start with the steps that you have taken to minimize risk to them. So explain how you have cleaned the contaminated area, how you've notified potentially contaminated employees, and the steps that you've taken to make sure that they are safe and healthy. Last time we gave this webinar, we had a question, what if an employee doesn't self-report, but the employer notices symptoms? If the employee doesn't self-report, but the employer believes they're exhibiting symptoms, they can in fact send them home. Employers should take appropriate steps to keep their workforce safe. Okay, so the last thing you need to do is you want to make sure if an employee tests positive for COVID-19 that you take the necessary steps to help health officials by providing the employee's work schedule, where the employee was working, the last day the employee was on site, who could have come in contact with them, and contact information for the employee or anyone they came in contact with. So going back to all of those documents that I asked you to take in terms of testing, in terms of tracking employees who are there, one, those logs will help you figure out who showed up for work that day. But two, I need you to keep some additional logs. As a practical matter, you're probably not doing this right now, but I would recommend that employers create daily logs and list all of the employees who report to work, all the employees who report and what shift they're on, where they are working, if they're attending meetings, who they're contacting. And so this could be simple enough, a job of collating all of the information that you already have, so you might keep your meeting schedule outside your conference room, or you might keep, attendance records. Collate all that information into one document because you might be asked by health officials to provide that to them in order to effectuate contact tracing. And employers in Kentucky now have an affirmative duty to help health officials contact trace. And so this information will make your life a lot easier going forward if you've already collected it and you do it on a daily basis. All right, I think that's it for me. And so I'm going to turn it over to Cindy Effinger, although I have no idea how, but I'm hoping Brian can effectuate that for me. Let's see.
All right, Cindy, if you would share your screen.
All right. Okay. Hi, everybody. Before we get into the legal exposure, Brian popped up a question that follows up on one of what Claire was saying about the daily temperature checks. Those temperature checks should be, if you're doing them, if the employees are self-assessing, there should be a mechanism by which it's reported every day into the office. And those logs should be kept and obviously kept confidential. I'm going to talk a little bit about employers' legal exposure and liability for these in my presentation as well. But the question was, should they be turned in daily? And yes, they should, because we have an ongoing obligation. So generally speaking, the implementation of the employer's affirmative duties that Claire has pointed out that basically followed the 14 points Governor Beshear has issued in the Healthy at Work initiative, coupled with existing and new laws, exposes businesses and employers to all sorts of different legal liabilities. And we have to think about things not only the way we have been in our traditional employment law analysis, but we also have to think about it in this new environment. Claire emphasized the stress and anxiety that our employees are undergoing at this point. And I think that we can't stress enough that communication is going to be the key to combating that in some way. We have to communicate with our employees about what we're doing and how we're trying to keep them safe. We're also having to remember that some employees are being called back to work, having been on unemployment and maybe receiving more on unemployment than they had been at work. Maybe they have a fear, whether rational or not, about their exposure, and they just want to stay at home. They're going to have to tie or wrestle with the fact that they don't still have childcare, but now they have to come back to work, potentially losing income if they don't. So there are a lot of fear and anxiety going on within our employees that will ramp up this legal exposure, because that is where employees will look. I'm sure that every one of us on this call has heard someone at some point say that an employee has said, well, my rights are being violated, or the Constitution doesn't allow this. And without this clear communication, we're going to be putting ourselves at risk. So with Governor Beshear's 14 points in the Healthy at Work initiative, every business must have a plan and policy in place to address these 14 points, distribute and implement that Healthy at Work initiative, and more importantly, enforce it. That is going to be our requirements and our liability, and that's going to be the basis for how we can protect ourselves as a business going forward. So, Brian, it's not advancing on my end. Can you advance to the next slide? I don't know why it's not advancing. Hold on. Okay, here we go. So one of the things we're going to start with is there are several acts that are new and several that are existing that I want you guys to all keep in mind when we're dealing with these different employee issues. We've got the new Families First Coronavirus Response Act that Claire touched on. I'm going to go into just a little more detail. We're also going to talk about the ADA, the FMLA, the National Labor Relations Act, OSHA, the CARES Act, and of course the Fair Labor Standards Act and Kentucky Wage and Hour Act. Because all of these acts now we have to consider when we're dealing with our employees' requests for leave, their understanding of their rights. At this point, everyone as of April 1st should have had the Families First poster put up within their workforce. But this is the newest law, and it is one that is causing significant questions and confusion. Although it seems fairly straightforward about when you're entitled to leave, most of the leave requests are not fitting neatly into the act. So we also have seen there have been lawyers who have updated their websites soliciting business or soliciting plaintiffs whose rights have been violated under this act. Not only whether they've been getting the paid leave, but perhaps retaliation provisions or retaliatory conduct under retaliation provisions that could expose you as an employer to potential liability. So employees are scared. When they have a cough or they have a shortness of breath or they're worried about someone in their office, are they going to try to use one of this act to get some paid leave? We talked about those temperature screenings, and when people are reporting, for example, if you get that report in on a self-screen or you're doing the in-person screen and someone says they do have a new cough or perhaps they have a fever, does this act apply? When does it apply? Well, if they're seeking a diagnosis, then they would get that 80 hours of paid leave would be triggered. If they're not seeking a diagnosis, then the 80 hours of paid leave is not triggered and you can default to your own paid time off policies. So like Claire said, there are 5 or 6 different areas where this leave is going to come into play, and you're going to have to figure out when the act comes into play to ask for that leave. So for example, we had a question earlier this week where an employee believed that she was exposed and is waiting on a negative test, but she also had a fever. So while she's waiting for the negative test, or a positive test for that matter, that would be paid leave. If the test does come back negative, but the employee still has a fever or otherwise needs to stay home, this paid leave wouldn't come in. You can switch over to your traditional leave policy because they're no longer seeking that diagnosis, but they're still sick and need to be off of work. We also have to remember on this act that there is no requirement that the employee actually produce a doctor's note. Practically speaking, that's going to be very difficult, right? Because you as an employer, when all of your leave requests and your paid time off usually deal with getting that doctor's note. You might also need that doctor's note to justify the tax credit under this act. So you would at least need to ask your employee to provide the name and phone number of the provider they're seeking a diagnosis from in order to trigger this leave. Another example of questions that have come up under this act is recently our governor instituted a travel restriction that if you travel out of state for vacation, for lack of a better word, you're supposed to self-quarantine for 14 days. So if, for example, we've got Memorial Day coming up, you know that your employees are going to go out of state, Tennessee, for example, Ohio, any vacation, they're required to self-quarantine. If you know that they have gone out of state and they're not self-quarantined, I do believe that you could be, as a business, responsible for making sure that they do self-quarantine because you have the obligation to provide a safe workplace for everyone else. We're going to have a lot of employees that may not report that they've gone out of town for Memorial Day. They might take a vacation and not tell you that they're going out of state. So what is going to be triggered under this act if they do? So that 14-day quarantine, if they're not seeking a diagnosis, they're not entitled to 80 hours of paid sick leave. So it also is very confusing because if I come back from my Memorial Day vacation out of state and I get a test on Monday and I'm negative, I'm still required to quarantine for 14 days. But I've already gotten my diagnosis. So at what point does this act require those 80 hours of paid leave? And I think that's going to be an ongoing question and dialogue with our businesses. But the act is clear that unless you're seeking a diagnosis, you would not be subject to the paid leave. So as a result of that, we've got a few questions that pop up with our own executive orders and how and when the paid leave will be triggered. With that, of course, employees want to be paid. They don't want to use their paid time off. There could be some tension that goes that goes between the employer and the employee, what they're entitled to and what they're not. So I go back to having that plan in place, having your Healthy at Work initiative, and making sure all of your policies are updated and clearly communicated to eliminate the questions that are floating about. So leave issues, they should have been in this leave for the families first should have been in place since April 1st. You might have had some employees that have already exhausted all of those 80 hours, at which point they are not entitled to any more leave because it was capped at 80 hours. You also have employees who've been taking that extended family leave for their schools where their schools were closed. And if they went out on April 1st, that leave is going to expire June 30th. And then if daycares or camps are not open, employees are going to be, who have childcare responsibilities, might also be stuck in a place where they might not be able to come back to work. But the most important thing to remember for the Families First Act, whether it's extended paid leave or the extended family leave, is there must be a qualifying reason. Employees must know what that qualifying reason is, and they must understand how all of the executive orders that impose responsibilities on the individuals and on the businesses work in conjunction with this leave. There is an exemption for small businesses of 50 or less employees. And those businesses might be able to take advantage of not providing the extended family medical leave, those 12 weeks of leave, if and only if they can prove that their business would be vulnerable financially. There are 3 separate reasons, most of which have to deal with having sufficient workers to do the essential business of the company. Healthcare employees are also subject to an exemption. And that would be for both provisions of this act. So if you're in the healthcare field, that would not be that you as an employer can exempt everyone. The regulations require that it is done judiciously or carefully and on a case-by-case basis. So with each leave request, you would have to evaluate that to determine whether or not that you would provide the leave for these particular employees. This act also has a retaliation provision. So we're going to want to make sure that we are keeping mindful of that when we're making decisions on granting or denying leave. One interesting thing when we're talking about bringing people back to work is that the Department of Labor has made clear that if an employer does not have work for the employee, this act does not apply. So if you've got employees that want to come back to work or that maybe are at work and you need to lay them off because there is no work, the layoff could trump this act, because if there is no work, the leave is not required. So when we're talking about bringing people back, we're talking about laying people off, we also have to be mindful of those retaliation provisions. So if you are laying off a large percentage of people or not recalling a large percentage of people who, for example, would need that childcare provision, or people who would otherwise maybe you know or are aware of underlying health conditions, or you assume they have an underlying health condition, and you're not bringing them back for those reasons because you don't want to provide the leave, that could be a problem. So if you're in a situation where you've had people on layoff or furlough and you're bringing them back, and let's say you have a few employees that you know already have small children who cannot be home alone, and we know schools, daycares, and camps are not open, you're going to have to be very careful about how you're bringing people back in a sort of an objective way, so that you don't selectively eliminate the recall for those people who you know would be coming back and requesting this leave if they did come back. They might not have exhausted those 12 weeks if they've been on layoff or furlough. Those 12 weeks would still be available to them for the summer. And again, I think employees, you might see some employees who are going to look for ways to be paid and stay home, whether it's because they truly have issues that they need to tend to, or because it's more convenient for them. So we are going to have to look at our recall policy to make sure that it's done objectively, clear identified, doing it on a seniority basis or essential business operations. But at the end of the day, I think we would still want to make a list of who we're bringing back and why, and put that against our traditional notions of employment law to make sure that it doesn't have a disparate impact on a particular group of people. So another thing that we have to remember when we deal with these leave issues is how the ADA and the FMLA also interact with the Families First Act and bringing people back. So the first thing that I look at when I'm thinking about returning people from telework are these ADA issues. So in the past, any one of you who have dealt with an employee who requested work from home as an ADA accommodation pre-COVID, you might have said it's not feasible, that we don't have the technology to do it. I need you here. That on-site presence is necessary because of the nature of your job. Well, we have proven in the last 2 or 3 months that telework is doable. And I bet that we also have employees who have received email messages and text messages from their supervisors for congratulating for a job well done. Now we're proving that these work from home accommodations are in fact reasonable, and they can be accomplished in a way that when we are returning to work, we're going to have to consider this. So if you've got an employee who says, I'm immune compromised and I don't want to return to work, and I want to continue to telework, if your response pre-COVID would have been, no, I'm not going to let you telework, now we have to reconsider that. Obviously, that could also have an impact on the people in the office, morale issues, and other issues. But we now have to consider if the ADA is going to allow us to continue those accommodations for individuals who might be immune compromised or have other issues. Same with any other underlying health conditions. We talk about temperature checks and the ADA and EEOC guidance on that. One thing I want to also point out to you is liability for temperature checks. So obviously, Claire talked about the executive order requiring us to either do the on-site screen or the self-reporting. What are employers' responsibilities in terms of their potential exposure? So I would highly recommend that anyone who is receiving that information, whether they're doing the on-site test or receiving the information from a self-screen, sign a confidentiality agreement, knowing and understanding that screener's obligations with regard to confidentiality of the employee records. Asking those questions, if it's an on-site test, it should be all that is done. There should not be a stray question that says, ask about any other underlying conditions, because that could lead into some ADA issues. You also have other employees around who might be standing in line on those on-site screening. We've got to protect their confidentiality there as well. We have record retention issues. For those contact tracing requirements that the governor has implemented, we have to make sure that we keep our records and we keep them in a confidential manner. We also have to remember human factors and human error. Whether you're doing an on-site screen or the person is receiving information through the self-screens, you can imagine a scenario where employees are nervous or anxious, and perhaps they hear Peggy down the hall is coughing, or they see someone who's sweating and perhaps has a fever. Is that person going to go to your screener and say, look, I'm a little concerned about Peggy. What was her temperature this morning? You have someone that would ramble, fill silence in, that would answer those questions. Everyone needs to be aware that these types of questions and communication should be very limited and be kept extremely confidential. And it is important to train the screeners and have them sign agreements that they are going to adhere to it. OSHA issues, I think, are going to be one of the things we see the most. I think I've received a lot of questions about this from our clients discussing the workplace initiatives that are required. What do you do when employees refuse? What do you when employees say that they won't provide information about whether they've gone out of town or out of state? And what our responsibility and liability are, our liabilities are. With Claire's outline of those 14 points that the governor has initiated, that's our first step. Let's put that in writing. Let's create a plan that is specific to your business. Every single business is going to be different, whether you're a bank, whether you are an entity that has visitors, whether you're a manufacturing facility. You're going to have unique challenges that are faced within that environment. So we start with the governor's 14 points. They're vague, and they're intentionally vague because they need to apply to a wide variety of employers. But then we also have to look to CDC and OSHA guidance. What are the requirements, or what's the best practice in keeping the environment safe? The 14 points have sanitation guidelines, so you should have a sanitation plan. They have testing guidelines. They have the screening guidelines. With that, that is your initial start to prove that you have complied with providing a reasonably safe work environment. But we all know that employees have their own ideas of what a reasonably safe work environment is, and employees have their own ideas of how they're going to implement or abide by them. So we as employers, whether it's a supervisor, HR director, or the CEO, have to make sure that we are staying on top of not only our plan, but the communication and the enforcement. So when an employee comes to you and says, I don't believe, I've seen employees walking down the hallway without masks, and that's an unsafe work environment. Well, if we look at our governor's order, if you're walking down the hallway without a mask, it is an unsafe work environment. So what do? How do we address that? We have to address the employees who aren't complying. We have to send them home. We have to discipline them, unless, of course, they've got an underlying health condition that would require them not to wear a mask. There might be some breathing issues that would prevent someone from wearing a mask. There might be a safety issue from wearing a mask. We have to communicate that we are trying to enforce it. And of course, that person who complains is protected from retaliation. We have to remember that when we're dealing with other employment issues going forward. So the OSHA issues is a start. We want to make sure that we have a plan in place, that it conforms with OSHA and CDC guidance, and that we not only implement it, but we enforce it when those complaints are brought to our attention. And even when they're not brought to our attention, we have to enforce it. So if you as an employer, as a supervisor, see someone not complying with the social distancing guidelines or the sanitation guidelines, you have to make sure that that is brought up. We recommend that Healthy at Work team, or the pandemic team that Claire discussed, the officers, are the ones that have that communication. Because with every aspect of employment law, consistency is a key. So the information should be coming into the team and going out from the team, so that all of your policies are enforced with consistency and uniformity, so that no one feels that they're being discriminated against or retaliated against in any way. You should also have a mechanism for people to submit those complaints, just like you do with any other type of complaint, whether it relates to harassment or discrimination. So the types of complaints we're going to see at OSHA issues are going to be PPE issues. Is the employer providing sufficient PPE? Has the employer provided sufficient training on donning and doffing of PPE and disposal of PPE? Do we have training on sanitation? Is there sufficient disinfectants for everyone to use? Is there social distancing enforced and in place? Those are the types of complaints I think we're going to be seeing in terms of the OSHA issues. For those of you who have employees who travel in cars, are we limiting the number of people in cars? How are we doing that? How are we addressing the issues that the employees are bringing to our attention? And we also have to remember behind all of this that those employees who have small children at home are going to be torn with trying to come back to work and comply and also take care of their children. And so they will be looking for ways to find a way to go home. They'll be looking for ways to create an unsafe work environment, or at least the illusion of an unsafe work environment, because they have their own fears, anxieties, and issues that they're trying to navigate and juggle. Here are a list, and I think we're going to be able to get this PowerPoint out to everyone, some of the OSHA standards with regard to record keeping and face protection, sanitation, et cetera. One of the things that has come up is what about exposure to COVID in the workplace, and what is an employer's liability there? Workers' compensation is generally going to be the exclusive remedy for employees, just as it would be for anything else. However, we also have to remember that there is an exception to the workers' compensation statute in Kentucky for willful disregard or willful conduct. So employees who are severely impacted by this might look to workers' comp or might look to suing employers for their exposure. And there's one example, at least right now. There was a gentleman who worked at Walmart who's unfortunately passed away. He was 51 years old. He worked there for 15 years. This lawsuit was filed in April. Obviously, in April, we had less guidance and less information. But the allegations in the complaint were such that he is trying to avoid, or his estate is trying to avoid, the workers' compensation bar. They allege that Walmart failed to warn employees that coworkers exhibited signs and allowed people to return to work knowing that they had signs of COVID-19. It alleges that they failed to implement social distancing policies that were advised by the government. They failed to provide appropriate PPE and failed to abide by OSHA guidelines. This is a roadmap for trying to avoid the workers' compensation bar. We now know that we have to implement these self-screens or on-site screens, and that if employees are exhibiting signs, they must go home. Employees aren't going to necessarily want to go home, because if they go home, they might not be paid. We have to make sure that they go home regardless of that struggle. This lawsuit against Walmart is certainly going to be a test case, but it certainly outlines and gives us as employers and businesses an understanding of how we could be subject to a lawsuit, and unfortunately have to deal with it even if we're successful at the end. A good reminder, all of these statutes have penalties. And here's just an outline from OSHA of the range of penalties that could happen per violation. And per violation could be an individual, it could be an individual act. And so it's just a good reminder that, that there are substantial penalties. There are also provisions in these laws for attorney fees to be paid to the prevailing party. And so if an employee brings certain actions, we want to be careful because you've got penalties and attorney fees that could possibly be imposed against you. All of our laws contain these retaliation provisions, and this is just a reminder that the filing of a safety complaint with OSHA, requesting accommodations into the ADA, requesting sick leave or extended family leave under the Families First Act, all have retaliation provisions. Claire asked you to, train your supervisors on these acts, and I would also make sure that that training includes a reminder of the retaliation provisions and how serious that can be, because that is where most of, if a claim wasn't a very good underlying claim, but there's a retaliation conduct that could convert a very defensible claim into one that we have to deal with for a while. So I want to briefly touch on the National Labor Relations Act. This act also could impose liability on employers, or be an avenue for liability for employers, even if OSHA didn't apply. So OSHA is basically looking for a safe work environment. and the employee has to prove that it is unreasonably unsafe. So if you're following the governor's guidelines, you're enforcing it to the best that you can, you are implementing your policies, you're looking at CDC guidelines, it's going to be difficult for an employee to prove that it was an unreasonably unsafe work environment. The National Labor Relations Act, however, it applies to all employers, not just unionized employers, but it is going to impose liability if the employee has a good faith basis for believing that the work environment is unsafe. And that is a different standard, and so it gives a different avenue of liability. Traditionally, you see this, and we've got an example of workers who refused to go to work citing health and safety concerns when they were exposed to electrical cables on a job site, and they feared they'd be electrocuted in the rain. At the end of this particular case, the employer paid $50,000 in back wages, offered to reinstate all of the discharged employees, and it resulted in a significant time and expense for the employer. And this is what we're trying to avoid. COVID-19 would also fall under the National Labor Relations Act if 2 or more employees band together to address terms and conditions of employment. And so with that, we have to remember that there are multiple avenues of recovery for our employees, and we have to know what the different standards are and what the different responsibilities are when employee complaints come in. In this particular act, if an employee comes in and says, I am speaking on behalf of multiple employees, that would also trigger this act. So we have to be aware that the obligations imposed by the governor, the obligations imposed on every employer to provide a safe and sanitary work environment and enforce social distancing rules are going to implicate all of these different acts, including the health and safety acts and the ADA and FMLA and all of the different discrimination statutes that we've already been dealing with. So under the NLRA and OSHA and everything else, this is a summary of what Claire had talked about, the different policies that have to be implemented. We have to make sure that we have a policy in place for isolation of employees who are exposed, identification of employees who are exposed or test positive. We have to have confidentiality provisions in place. We have to know how to document and retain our documents for our contact tracing requirements. We have to enforce and be consistent in our enforcement. We have to have we have to have flexible scheduling and leave policies to accommodate our obligations and and to provide a safe work environment. The contact tracing requirement, I think, is going to be interesting because if you have a case that's reported to the health department and the health department comes in, their first thing they're going to ask are to look at the schedules, the visitor employee logs to try to identify the people who we've come in contact, the exposed persons come in contact with. If you have not complied with your duties there, does that trigger a Department of Labor investigation? Does that trigger something else to come in to say, perhaps this employer isn't providing a safe work environment and maybe you could be shut down? The health departments have the capability to shut down employers and businesses that are not complying. So if there's a positive case in your facility and the health department comes in, if you have not had these policies in place, you have not had the documents retained and kept confidential, and you don't have the ability to do the contact tracing, it could mean a shutdown of your business, which of course would be detrimental and cause all sorts of other issues, financial and otherwise. So it's our job to stay on top of the new guidance that comes out seemingly daily from the governor's office and from the CDC, to release that guidance and communicate it with our employees and stay on top of it and address their concerns in a compassionate way. We are all facing the same issues, and we have to be compassionate in how we're implementing our policies and dealing with our employees. So I want to also identify and discuss before we conclude, because I think we're close or we're over, the Fair Labor Standards Act. With all of our work from home and other issues, the Fair Labor Standards Act, we have to make sure that we're complying with our timekeeping requirements and that we're properly documenting and paying overtime. We can't emphasize enough that this could be an opening to other complaints unrelated to an unsafe work environment, but just wage and hour complaints. And it could be the tip of the iceberg for a lot of different avenues of liability. So I want to make sure that we have if we have any questions, because I know we've gone over. This is certainly a difficult time for everyone to keep up with the different laws and the ever-changing responsibilities. And I'll also ask Claire if she has anything else to add. I don't necessarily see any questions right now, but we do appreciate your time. And Claire, if you want to have anything to wrap up, I'll leave it with you.
I think I'm muted. Oh, no, there I am. No, I think you know, if you guys need any help, if you have any questions going forward, I know we went over a little bit, so you might be rushing to get back to your daily grind, but feel free to email either Cindy or I, and we're happy to answer any questions that you guys have.
All right, thank you very much. Appreciate your time.
This is advertising material.